We welcome you to this webinar. We're really looking forward to having this conversation. I always like collaborating with other attorneys at our firm so I can really get a good feel for the scope of their practice areas. My name is Jonathan Bench. I'll do a brief introduction, then I'll let Paul introduce himself, and then I'll give you the rundown. So I'm an international business attorney at Harris Bricken. I'm based in Salt Lake City, Utah, and my practice is probably 50% related to blockchain right now. 18 months ago, I had virtually no blockchain clients. So we just started getting inquiries about smart contracts and really didn't know much of anything. So as I'll tell you more in my presentation, I spent a lot of time educating myself first and learning the vocabulary, really figuring out what makes blockchain different. When I discovered how international blockchain really is, the whole Web3 tech reaching across borders, I was very interested to see how I could play in the space. My particular area of expertise is China. I speak Chinese. I do business transactions with Chinese companies and with US companies in China. And in the last, especially 6 to 12 months, I've been working much more in the blockchain space. So I'll share some more later about my kind of wide practice area. I'm a corporate generalist. I do transactions of all types across borders. And that generally involves from early company formation through big life cycle events, financing, M&A, all the way through shutting down companies and swapping out owners. So that's my introduction. Paul, do you want to jump in for a minute and say hello to everyone?
Sure, thanks, Jonathan, and hello to everyone. Good afternoon. My name is Paul Coble. I'm an intellectual property attorney with Harris Bricken. My practice covers really all types of intellectual property, patents, copyrights, trademarks, trade secrets, and unfair competition across a variety of different industries. I've worked in everything from pharmaceuticals to alcoholic beverages. My practice currently focuses on highly regulated and emerging industries, including cannabis, psychedelics, and blockchain issues. So I'm really excited to be here and talk about some of the IP nuances that are unique to Web3 and NFTs and things like that. So great to be here and look forward to the conversation.
Thanks, Paul. Great to have you. So today we're going to be, an hour is really too little. When I started getting into Web3, I spent probably 6 months just learning vocabulary, going to events, talking to people, asking dumb questions because there was so much to learn. So I'm going to start out giving you the left side of the screen is me, the right side is Paul. So we're going to start with some of the key terminology, including what is blockchain, and knowing, of course, I know some of you are probably deep practitioners in this space, development teams, founders, and so some of this will be a repeat, but it's also helpful for you to understand how lawyers think about this industry, because a lot of the traditional legal terms map over very nicely, even though we're using new terms in Web3. A lot of the terms are not necessarily new from a legal standpoint. Then we'll talk a little bit about the problems that Web3 is trying to solve. I'll run through digital assets and smart contracts, DAOs, and then a couple of case studies based on some compilations of projects that I've worked on or I've been asked about. And then if I have time before I kick it over to Paul, I'll talk a little bit about the metaverse because it's a kind of interesting beast in this space too. But really, we could spend an hour talking about any one of these topics. So it's more just to share with you our thoughts and how we think about things, and for me to get to ask Paul some dumb questions about his practice area, and then we can let you ask us all of your smart questions. So when I'm looking at as a transactional lawyer, for me, every contract starts out with definitions. I have to know what we're talking about. I have to make sure everyone's kind of talking about the same things. And so on the left is terms that I use as a lawyer. Actually, founder, I put founder up top because founder is not technically a legal term. I know that founder is thrown around a lot. My founder, my co-founders, and in no law in the United States, at least, will you ever find the term founder. And so I just need everyone to understand that founder as a title is not really a thing. You still have to, under the LLC Act, or under the Corporation Code, or under a DAO legislation, you're going to have some kind of legal title that you map back over to actual laws in existence. But I understand that the cachet that comes with being able to call yourself a founder or a co-founder. When in our space, we're dealing a lot with as Paul's going to talk about trademarks and patents. My world is very much tied up in assets, and when I'm doing transactions across borders, very focused on different jurisdiction laws, what happens when you have a conflict, where do we fight about this if we need to fight about something, and also the types of entities that are involved. Of course, those of you who are in the space know that especially when it comes to DAOs, which I will talk about in a little bit, there are any number of entities, in the US, offshore, any number of jurisdictions where we can house a DAO or house DAO-like functions. And so it's been quite an education for me as a lawyer in the US, going from understanding, for-profits, nonprofits, LLCs and corporations, to trying to understand where does a DAO fit into the scenario. And then on the right side, of course, the terms that those of you who are in the industry will be very familiar with, terms like decentralization, which lends itself to other kinds of shortened terms like DeFi and DeSci. Then we're talking about tokens and coins, and what do those mean actually from a legal perspective? What are the rights that are tied to those? And we use terms. Often we use terms interchangeably. They're not really standard in the industry. DAOs are not standard terms. Even coins and tokens are not standard terms. We have to understand what all those mean. So I wanted to give you just an array of terms here to help peg your brain to as we move forward. So for those of you who don't know what blockchain is, we're really talking about computer software. And it's a special kind of computer software. Those of you who are my age, I was in college in the early 2000s, and I remember downloading Napster at my university computer lab because I wanted to listen to music, and I could get music from anywhere in the world. And that was a peer-to-peer software. It did get shut down, and they had to pivot quite a bit. But in the early days, when we were all digital pirates, we could pass files back and forth. We could download movies back and forth. And those were through decentralized means, where it was just my computer to someone else's computer via software. So blockchain is really a kind of a beefed up version of that, where we don't just have my computer talking to your computer. We have my computer talking to yours, talking to everyone else that's running the same software for a purpose. And so we have, in computers that are running these programs have different roles and responsibilities in keeping the network updated. And then we have these blocks. And often we're trying to fulfill transactions. We're trying to make something happen. We're not just sending, in the Napster example, I'm not just sending music to someone else or receiving music from them. It's a transaction, so I have to pay for it. There's some kind of value that's being traded. Maybe it's music for music. In the current space, maybe it's an NFT, but there's always some kind of payment going on. And so the different blockchains, one computer, I could be running Bitcoin, I could be running Solana, I could be running any number of chains and participating as a node or as a validator to make sure that the network stays up and running. And the whole goal is to make sure that the transactions we have an immutable record of the transactions, which means that it can't be changed. So there's a lot of value and practical applications to this. The technology dates back way before Satoshi's white paper. We're talking Satoshi's white paper that came out, I believe, 2008, referenced some early work done in the 80s by a group of computer scientists that were knowledgeable in cryptography. So this technology, these ideas have existed for a long time, but as the technology has grown, we've been able to have more mass adoption. So that's fundamentally what blockchain is. Now, looking at this is the visual representation of what I described in terms of how these transactions are organized. So in a centralized world, so let's just say Facebook, we have Facebook in the middle and not these two people transacting. So and then we don't have the computers all connecting to each other. Everyone has to go through Facebook in order to get data back and forth. In the decentralized world, we have the computers all linked together, and then they're all facilitating the transaction in the middle. So you will hear a lot about these terms of centralization versus decentralization, and ultimately we're talking about control, and we're talking about access, and that indicates who is going to be participating in these transactions. In terms of blockchains, there are fundamentally public blockchains and private blockchains or permission blockchains. So public blockchains are those that are really open. Anyone can go and download the software. They can download the whole history of transactions. They can participate, and there are barriers to entry in that, but it's basically an open system. A private or permission blockchain means that there are some some barriers to entry that you have to qualify in order to be a part of the network. A lot of private companies, big private companies that we've all heard of, are using private or permissioned blockchains because they like the redundancy of having immutable ledgers. They don't just have one security vulnerability point. They've spread it out. And so you'll hear terms like proof of work and proof of stake, and those are two ways to participate in public blockchains. And then you'll hear more of permission blockchains. There will be some other criteria that gets you into the network. And in terms of keeping the network updated, they're all built to reward good participants. So if you are a good participant, you validate the transactions the way you're supposed to, you play by the rules, then you get a reward, and if not, then you get punished and you can get kicked out or ostracized somehow. So blockchain is really fascinating. It's really a revolution of sorts, and quite a digital revolution that stretches across borders. And we're dealing with some very key topics here. You ask why would anyone want to use this software? What's the point? Is it really better? What are we doing with it? And these are some of the common themes that that entrepreneurs, founders will talk about it. I was kind of shocked, not shocked, but surprised when I went to these, started going to some of my first blockchain conferences to hear about these terms. About people talking about pushing decision making out even farther. We don't want just our national boundaries to decide how we interact with the world. We don't want our governments to be the only ones that decide how we interact with space. Any kind of, anything where we see countries and large corporations have traditionally taken a front seat in the decision making. This software has made it so individuals can pool assets and other resources and deploy them in new ways. So it's very interesting. You'll hear a lot about people wanting to minimize the wealth gap. The 1% keeps getting richer and the other 99% gets poorer. So we're talking about democratically spreading the wealth and the decision making around. Second bullet point, we're talking about minimizing the need for intermediaries. So if you have ever tried to send a wire from one country to another, you know how long and frustrating that process can be. And a lot of the systems that are being set up now are helping to minimize the need for intermediaries, for trusted intermediaries that would otherwise play a gatekeeping function. You'll hear a lot about directly rewarding contributors, a democratization of the way that people are compensated and recognized for what they contribute to an organization or to a venture. You'll hear a lot about transparency and immutability, where we can if there are no closed systems, if all of the data is open for examination, then we know we can easily track who is trying to commit fraud and where did the money go. We can root out human errors if we are using machine code that is essentially flawless in some regards to create transactions, and we know that there's no human error involved in transposing numbers or letters or anything like that in a transaction. Liquidity is a huge thing. You will hear about liquidity all day, every day in blockchain. And by that, we mean a more efficient movement of capital around the world, more efficient allocation of capital as well, and participation rights from people, back to the democracy point, not just the wealthy, not just the elite, not just companies with connections to venture capital and private equity, but anyone with any kind of venture that looks like it could have legs could raise funds from anywhere around the world. That's exciting, and also potentially fraught with a lot of issues, as you can imagine. Regulation is also, less regulation is also the I don't know how to say it, it's also the rallying cry of the decentralized world. People want to be able to have the free flow of capital. They want to be able to have the free exchange of ideas. I told you that I work a lot with China, and certainly there are countries in the world where we don't have the free flow of capital or the free flow of ideas. And so you can understand the draw to this, that people are kind of pushing toward this ultimate freedom. Now, I've taken the last slide and compiled on the left side, kept the main points on the left side. On the right side is the counterpoint. So the point of when we get into this space, and this is me as the lawyer talking, especially as a corporate lawyer, where I'm dealing with founders, and founders want to keep, everyone wants to keep money in their own pockets if they can, unless they're truly have unless they truly have motives to kind of benefit everyone in the world. I think most people want to put money in their own pockets first while also doing good. I don't know too many people who can stay poor while making others rich. It just doesn't work that way. But so often we have founder teams that want to democratize. They have an idea, but they say this is something that should be spread around. And so we run into the question of when is democracy too much democracy? You take the DAO context where we have people all over the world, and DAO is, I do have a slide later, but I should give you a little background. So a DAO is a decentralized autonomous organization. And as one of my high-tech coder friends said when I went to lunch with him the other day, and I was explaining this to him, he said, "Oh, it's just a tech-enabled. A DAO is just a tech-enabled LLC." And functionally, that's a good way to think about it. That's a good shortcut for you. So it's a tech-enabled business venture with people all over the world with the ability to bring capital together. And so you can imagine that there are points in time where you have too many people involved, too many cooks in the kitchen. And so when we're dealing with blockchain ventures, that's certainly one of the primary issues, is how many people is too many people, and how do we make sure we have decisions, and how are people heard while still preserving the whole point of the venture. Second point was minimizing intermediaries. So we can do peer-to-peer transactions, but those of you who have or have friends that have been involved in fraud in an electronic world, it's very easy to present yourself and your venture as something else. And so this issue of who can you trust and who can trust you, and how do you get to the point where you can really have true trustless transactions? And will we ever get to that point? I'm a relationship person, and so I feel like I don't think we'll ever get to that point with everything, but I feel like technology can certainly enable some of that. When we're talking about directly rewarding contributors, the legal issue that creeps up is, if we have developers all over the world, at what point do they become employees? When do they go from independent contractors to employees? And in the home jurisdictions, do they even have the concept of independent contractors? Because in places like China, they don't. There's no such thing as an independent contractor. When we're looking at transparency and immutability, when we have things out on the blockchain, as soon as they're out there, it's public, which means that any trade secrets and IP is out there for everyone to see. And as Paul will tell you, one of the fundamental issues with trade secrets is you need to keep them secret. If your trade secret's no longer a secret, it's no longer a trade secret, and your value is gone. When we're looking at liquidity, as many of you who have been paying attention the last few years, but especially since 2015, we've seen some booms and busts in the crypto space. And so certainly the issue of we want more liquidity lends itself to there just being too many tokens that don't really have real utility for anything at all. But they're still getting attention and provides opportunities for pump and dump. And there are issues that I'll talk about in a few minutes. Lastly, the idea of regulation. Less regulation in the marketplace means that if you have been wronged, that it's going to be difficult to enforce anything. You know, if we have the Wild West of the internet, where we have no central point of authority, no central governance, no central mechanisms, then how do you enforce anything? You know, if anything happens outside a smart contract, how do you really protect yourself? Some common crypto assets include, and crypto asset is kind of a blanket term. There are many blanket terms, but this is a decent one where we're talking about different types of cryptocurrencies, different types of NFTs, non-fungible tokens, and then different kinds of tokens in DAO context. So fundamentally, we're talking about rights. You know, we may be talking about different types of assets, whether they appreciate or not, whether they're considered currency or not, whether they have additional rights, how much intellectual property rights do they have. There's a big realm of we don't know. And if you talk to any accountant who plays in the space, they'll tell you all they care about is different asset classes. They just want to know, what does this asset do? Is it a new asset class? Does it fit into an existing asset class? And they will run with it the way they need to, and they'll let the lawyers and other people figure out exactly what they are from a legal standpoint. Smart contracts are very interesting, and they are a bit of a misnomer because they are not really that smart, and they are not really great contracts either. But fundamentally, a smart contract is like a vending machine. And this is a pretty common example where the contract itself is the machine. It holds the assets, it takes in the money, and someone who puts in money is going to be returned what they have put in for. You know, you put in the money, you hit A3, the bag of chips comes down, and that is the completion of the smart contract. And that will happen every time because that is what the machine is programmed to do. So they're getting more robust, and really the developers all say that they are working to solve all of the problems. They all believe there's a technical solution to every problem, and so these smart contracts will get smarter. But we're not talking about AI. We're not talking about any of those things yet in the smart contract, at least not in the mainstream smart contracts. DAOs are extremely interesting. I like DAOs for a lot of reasons, and they're fraught with a lot of issues as well. As you can imagine, when you take a group of people who are all over the world, and you don't have a formal business entity, there are a lot of issues that arise. One of them is liability, as in how do you protect everyone from each other's liabilities, and the other is how do you contract off chain. If you don't have a bank account, if you don't have a traditional entity, you can't go through the KYC and AML compliance. How do you really do anything except send tokens back and forth and send NFTs back and forth? You're really limited in terms of real world utility in this type of organization. But there are different ways that DAOs can be utilized, and so I spend a lot of my time as an international corporate lawyer dealing with structuring questions of where do we set up our venture, and how do we capitalize it, and what can we do and what can't we do, and do we need to be licensed? And those are the big questions. I have many smart, what I call Web 2 companies, traditional brick and mortar companies that want to know. They've heard about DAOs, they've heard their potential to capitalize, and just as a new source of income, a new source of investment funds. And so they want to know, is it better if we start a new venture as a DAO, or should we form a DAO in parallel to our existing company? Or should we take our existing company and turn it into a DAO? And there are a lot of different avenues that these can be applied, but it's all difficult because you're crossing in the US, you're crossing state boundaries. In the world, you're crossing international boundaries. And oftentimes there are a lot of people who don't want to disclose who they are. They prefer to remain anonymous. They don't want to deal with tax reporting. They don't want any of the real issues that come up, even though basically every taxing authority in the world knows what's going on and is writing rules or has written rules around this. And those, at least in the US, those date back from 2012, 13, 14. And so there are those who say we don't have the regulations we need from the SEC, from the higher certain parts of the US government, but the IRS has been involved in crypto for almost 10 years now. The issue with international payments. Anytime money crosses borders, every participant, everyone who's involved, including those who are sending the funds, but especially those who act as intermediaries, have to deal with anti-money laundering, anti-terrorism, and of course, any amount of additional regulation makes these less seamless, right? They lengthens out the time for the transactions, and we don't have the seamless time that people crave in these kinds of peer-to-peer transactions. So certainly payments are an issue. Even getting bank accounts now, as we continue to have crypto in the headlines, it's not getting easier for crypto companies to bank, and that certainly is a fundamental issue, especially if you have off-chain transactions that you need to accomplish, which many of them do. So I have just a few minutes before I turn this over to Paul. So I want to make sure that I give him enough time, because all of his topics definitely underpin mine very much. So first example is raising capital. So I've had several clients, international clients, with people, the development team, some in the US, some other places, and they have an idea, and at this point, the ones that I've been talking to also have their own funding. So they have some money. A lot of them made money in the 19, 20, 21 boom. And so they've got money. They have to often convert their whatever token to a more traditional token, to fiat currency, to be able to pay our fees. But when they get through that process, then they're hiring us, and we're helping them deal with how to raise capital. And so initial questions are, we're going to be issuing some kind of token. And that token can be, I only have security token and utility token here, because in my mind, there are really two main branches of tokens. But for those of you who are not familiar with this area, you can think of a security token just like a traditional stock certificate, and a utility token more like a coupon, some kind of discount or some kind of benefit. And so we're talking initially, what do they want to do? I mean, the Web3 ventures are not that different from Web2. They just happen to be more difficult because they're more international and happen to have more technical components than a typical international company. So helping them decide what type of token are they really issuing, what's the functionality of the token, do they really need to be a Web3 company at all? So these are some of the questions that I ask these companies. Then we talk about entity registration, about whether or not they really want to form some kind of off-chain entity. Do they need an LLC somewhere or a corporation? Do they need a Cayman Islands Foundation company? Do they need a BVI trust? Any of these questions about what is the optimal place based on their current founder team, location, their risk tolerance, their compliance, their desire to comply with existing regulations. These are all important questions that I ask them and make sure they give me a straight answer on and they're all in agreement on. Then how much are we going to be using smart contracts and what types of business operations will really be happening, and what do we need to have tied to an entity? What are kind of lingering liabilities that could come out based on their business model, and which things can we kind of leave out there in the ether that don't necessarily need to be tied to an on-chain entity or an on-chain on-chain group. Next, the VASP is the Virtual Asset Service Provider regulations. There are many jurisdictions that are writing their own regulations now, and this is basically a crypto license to do various things in the crypto space, and it's very broad and encompasses basically anything that would have to do with a token. So after we decide what they're going to be doing as a business model, is their entity need to be registered, and do they need to be registered based on the type of business plan they're going to be engaging in? Then we talk about securities. If they're going to be issuing a security token where there's going to be some kind of revenue stream flowing down through the token, then we have to do a securities analysis. And every responsible economy right now has securities registrations, even those that have a vast regulatory overlay like the Cayman Islands. You can, if you're going to be issuing a token and also in the playing in the blockchain space, then you have to be registered with securities regulator potentially. You have to be registered with the VASP, and you have to have a full entity as well. And then if you happen to be a fund, if you're going to be an investment fund, then there's often another layer of registration for the fund itself and for the fund managers. So plenty of things to think about in terms of raising capital for either for a venture or to operate some kind of investment fund, whether that's going to invest in on-chain or off-chain assets. This is where I'll end, I think. I do have one more slide after this about the metaverse, but I'll leave it. If we have time, we can go back to it, but I want to make sure Paul gets his time. So I had another client, prospective client, that had a very interesting venture. So they had some family property in Costa Rica. His father had been a rancher in Costa Rica, and some prime property. There was some beachfront area. There was some lowlands where there was some rare butterflies that lived there and migrated there. And then there was this steep rise up to some highlands with an amazing overview of the beach, of the lowlands, of the beach, of the inlets. It was very picturesque. And so we went through this analysis of where do we raise capital? They didn't have the funding for this, but they had the real estate already. But they needed capital because they wanted to build some high-rise condos up on the top, and those would be high-end for-profit condos. They wanted to have some lower-end housing kind of around the ecosystem, but we'd have to be careful based on preservation needs, because they wanted to open that up as a research facility and certainly preserve the wildlife that relied on that area. And then we had to talk about where are we going to raise capital. Is this the kind of thing that we needed to keep in Costa Rica? Do we want to have it raising capital only in the US? Do we want to push out to other jurisdictions? And so we went through a pretty extensive analysis over 1 week, over one afternoon, kicking around all of these ideas and trying to figure out what do we do? Do we want to issue NFTs? Are the NFTs going to be security tokens? What kind of benefits do we give with the NFTs, and how do we attract people to this venture? So a whole host of concepts, a whole host of ideas. I hope I didn't go too fast, but I'm certainly happy to kick this over to Paul. I just have to remember how to do that. I think I can do it right there. Paul, over to you as soon as you have the control.
All right, thank you, Jonathan. And I should have my screen up now. All right, so I'm going to talk about intellectual property in Web 3.0 and kind of put little bit of finer point on some of the concepts that Jonathan introduced there. Before I get into some of the details here, I want to give a big overview of what is intellectual property. I often analogize kind of ideas and intellectual property ideas to clouds, where both are theoretically very powerful, might have a lot of value behind them. From far away, they look like they're tangible and have kind of a definite outline to them, but when you get up close, they're a little bit, that outline is a little bit fuzzier, a little bit more difficult to define, and of course, trying to commoditize it and use it from a practical value is very difficult. So intellectual property is kind of the umbrella term for a sets of laws that put framework around ideas, put some structure around these amorphous concepts, so that you and attorneys like Jonathan can treat ideas like tangible assets that can be bought and sold and licensed and utilized without compromising their kind of inherent value. So intellectual property can be broken up into three big buckets here of types of IP that have different purposes behind them. The first type is patents and copyrights. These are the only type of IP that's actually in the US Constitution. Patents and copyrights are designed to promote the advancements of science and technology through limited exclusive rights. Essentially, the idea is that inventors and authors have to expend certain time, resources, money to create new inventions and new creative works. And so they should be given an exclusive period after they do those things in order to recoup their investments without someone else coming in and freeloading off their work and just kind of writing off of their R&D expenses or all of their development costs. Trademarks and trade dress have a bit of a different purpose behind them. The purpose behind trademarks and trade dress is to reduce consumer confusion in the marketplace. So trademarks, service marks, and trade dress are all designed to help consumers be more confident when they see a product or service or advertisement in the marketplace, that they can be confident about who is the ultimate source of those goods and services. So when we're talking trademarks and trade dress, the most important concept is consumer confusion and the reduction of consumer confusion. That's going to guide how trademarks are delineated. And the last category is trade secrets. Trade secrets is an important category. Trade secrets can be incredibly valuable. Some of the most important or valuable types of IP in existence are maintained as trade secrets. Formula for Coca-Cola, formula for KFC, herbs and spices. Those are generally considered to be trade secrets. Benefits of trade secrets are that they are not time limited at all. As long as you can keep them a secret, and as long as they maintain commercial value as a result of being a secret, trade secrets can last in perpetuity. Similar for trademarks and trade dress, patents and copyrights, however, have finite terms and they will end at some point. Let's delve first into copyright here. Copyright protects original works of authorship as soon as the author fixes them in a tangible form of expression. What this means is original works of authorship are anything from literature to drawings, graphics, movies, songs, artwork, things like that. As soon as they're fixed in a tangible expression means as soon as they're written down, as soon as they're filmed, that copyright exists as soon as that happens. And it's important to remember that that this copyright vests at the time of creation, because you can't go back in time and change that. It will vest in real time, and you need to make sure that your legal framework is in place so that it vests where you want it to vest. Registration of copyright is possible, and there are a lot of advantages to it. I'm not going to get into really all of the details of registration. It is not a requirement to have it registered to own the copyright, but it is typically required either to apply for the copyright or receive the registration if you want to enforce that copyright in litigation. Last thing to note is that copyright is exclusively federal in jurisdiction, meaning that you have to deal with the federal laws and it has to be enforced in federal court. Some things to key in for copyright potential that are specific to Web3. Source code, of course. Any type of computer code that is being written is generally subject to copyright protection. But also artworks, graphics, anything that you are developing for your website often has the potential for copyright protection. Marketing documents, if you're putting together a pamphlet, brochure, or something that gets sent around, advertisements, all of those are subject to copyright protection. Algorithms are a really interesting source of copyright potential, and there's something that is going to be an issue in Web3 specifically. It is now, and it's going to be bigger going forward. The Copyright Office has said that algorithms can receive copyright protection if they are sufficiently creative. And what that means when we're talking copyright, creativity means exercising some sort of judgment. And so this frequently, more often than people realize, I think, does make its way into algorithms. If you are, for example, deciding which sources of data to bring in to train an algorithm, that selection of source material could be copyright protected, could be a subjective decision that leads to the creativity of the algorithm. If you are, for example, maybe weighting different sources, this happens frequently where you prioritize different sources or assign them different weights within the algorithm. That weighting often has a subjective business judgment behind it, and the process of including those types of variables in an algorithm can lead to copyright protection. Last one here is data sets. Again, very interesting, highly unsettled area of law. There is a very old case called Feist v. Rule, and that case held essentially that a copyright could not vest in a phone book. A rural telephone company was putting out phone books. Basically, they were just reporting whatever their customer said was their name, address, and they knew the phone number because they were assigning it. So they were just essentially regurgitating facts that either customers had told them or that they had assigned. There was no judgment in deciding who was going to be in that phone book or what their name was or what their address was. The phone book company was just repeating what had been told them. So that phone book did not have copyright protection. However, in that opinion, the Supreme Court said this is only applicable to these particular set of facts. It is possible that there might be a selection, coordination, or arrangement of data, including names and addresses, that meets the creativity bar for copyright protection. And we've actually seen that. The Ninth Circuit has some law on the books that I was part of at the trial court level that says that even names and addresses, if they have a sufficiently creative selection, coordination, or arrangement, could be subject of copyright protection. Corollary to that, to the data sets and algorithms, is this idea of subjective data having copyright protection. Subjective data is data that looks like it's data, but it isn't really. Some great examples are like Kelley Blue Book values or Zestimate, where it looks like it should be a value. It's a price on a house. But that price is really a representative of the company's opinion of what that price should be. Taking in a bunch of data, weighting it according to what their employees believe should be the case, and the output is a number, but that number has, in many cases, sufficient creative value to have copyright protection. So These are things to keep in mind, both when you're developing your own products, but when you are looking at data to incorporate into your own products. Certain data might appear to be factual data that is not copyright protected. But if it is the subject of, or the output of kind of a creative process, that might have copyright protection to it. All right, so what does the bundle of copyrights get you? Gets you the exclusive right to reproduce the work, to make copies. It also gives you the exclusive right to prepare derivative works from those copies. So that means taking that work and creating a sequel. If we're talking like a movie sequel using the same characters, same plots, same plot points or plot histories, those would be considered to be derivative works of the original. Similar, like if you take artwork and run it through a filter, that would be creating a derivative work. You also receive the exclusive right to publicly distribute the work, to sell or license it, or to publicly perform or display it. That frequently runs into issues when we're talking about copyrights in songs or movies or artwork that can be displayed publicly. That is a separate bundle of rights that you need to, if you're going to be doing that, either playing various copyrighted works through your platform, or displaying others' artwork, you need to be considering whether or not you have the right to publicly display or perform that work. All right, so let's talk a little bit about IP as it relates to NFTs. Jonathan introed NFTs earlier, so I'm not going to spend too much time on the details of it. But one critical thing to think about is NFTs are often used for artwork or works that themselves could be copyrighted. And there's a wide discrepancy between what people think they are getting when they buy an NFT to a particular artwork. On one hand, some people think that you only get an URL to the picture and really no rights or anything to use it, download it, or anything further. On the other hand, there's a school that thinks that you get full rights to that work to publicly display it, to make all the copies you want, and to make derivative works. The reality is usually somewhere in between, and that the NFTs are usually governed, if they're done properly, through a formal license that is included in the sale of the NFT, either on-chain or through a separate receipt. Could be done also through click-through license and things like that. I'm going to talk about in a moment. But the key is that the NFTs are governed by a license that will describe what the purchase of that NFT actually gets you. Do you have the right to download it? Typically, though this is an unsettled area, it probably is going to fall within fair use. And I'm not going to go too much into fair use because it's a topic we could spend an entire hour on it by itself here. But if you own an NFT to an image, it is probably fair use to download it for your own personal viewing and enjoyment, so long as you own the NFT. Once you no longer own it, it's no longer going to be fair use for you to possess that. And so read into that as you will. You're not likely to be brought up on an infringement suit, but be aware that that would no longer be fair use and would be infringing at that point. But so one of the keys here to NFT copyrights is that a full assignment must be in writing for copyright. An exclusive license must be in writing for copyright. A non-exclusive license may be oral or by implication. So that means that oftentimes, by just the nature of how these NFTs are marketed and sold, non-exclusive licenses are created through the marketing literature or just in the description of the NFT itself. Some examples of that are here. Bored Ape had on their marketing, when you purchase an NFT, you own the underlying Bored Ape, the art, completely. Moonbird similarly had, you own the IP on their marketing. Both of those were not actually accurate if you looked at the formal license that was associated with the NFTs that those companies were creating. To my knowledge, none of this has been litigated, but it did create a PR issue for these companies. And it certainly is something to keep in mind if you are marketing NFT artwork or NFT copyrighted material, that you want to make sure that you are calibrating your descriptions of that material with the actual license. And the more notice of those terms that you can provide the purchasers of those NFTs, the better off you're going to be. So, consider embedding those terms through in your chain receipts. Consider embedding those in the actual smart contract so that subsequent purchasers have notice and can view the terms of those conditions, those licenses. All right, so let's talk a little bit about trademarks. Trademarks differ from copyrights in that the central purpose of a trademark is to protect consumers from confusion in the marketplace. Trademarks can be words, symbols, colors. They can even be sounds, like the NBC chimes are a famous example of trademark sounds. They're anything that consumers would recognize as a source indicator, meaning that they understand that they associate particular goods and services with a particular source based on those source indicators. Like copyrights, trademark assignments must be in writing. This is kind of just a basic formalities, but there's a trick to trademarks, trademark assignments in particular, that the goodwill associated with the trademark has to be included, otherwise the assignment will be invalid. Trademarks have different strengths, and their strength is dependent on the different goods and services that they're used in. The spectrum on the screen here kind of shows you from the strongest on the left to the weakest on the right, the different types of trademarks that there are. So farthest on the left, strongest type of trademark is a fanciful trademark. This is a word that has no use, no meaning other than in this particular context. So Xerox is a good example. Doesn't have any meaning outside of this company. Consumers have never encountered that word other than as an indicator of the source of Xerox's products. Next, after fanciful, is arbitrary. These are words that have an understood meaning. Consumers would be familiar with the word, but not in this particular context. So for example, Apple or Dell computers, they're actual words, but not in the field of technology. So consumers only associate technology with Apple based on that one company. In the middle here, we have suggestive marks. Suggestive marks are kind of the weakest form of natural trademark protection. These are marks that suggest to the customer what the nature or quality of the goods are. So for example, Coppertone sunscreen. By the name, you can kind of figure out what the goods or services are, but another company could very easily market their goods and services without using the word Coppertone. So it's only suggestive of the mark or of the goods. Slightly on the other side is descriptive marks. These are marks that actually describe to consumers what the goods or services are. So Best Buy, you know what you're getting. You're getting a store that they believe sells the Best Buy. It is a store. However, descriptive marks don't inherently get trademark protection, but they can acquire trademark protection by being used over a period of time or with a very strong marketing campaign. So if you've used something consistently for about 5 years, we often say that a descriptive mark has acquired secondary meaning and therefore can be used as a trademark. On the far right end are generic marks. These are trademarks that, or marks that are so generally known or generally used in the marketplace that consumers don't associate them with a particular source anymore. Escalator, dumpster, examples of words that at one point indicated a particular source of goods, but because they became so widely used, they lost all of that power with consumers and became just a general term for the product itself. A lot of companies spend a lot of time and effort fighting genericide or genericness of their marks. So for example, Kleenex has undertaken a huge marketing campaign to make sure that, you know, people start using Kleenex brand facial tissues, or they include that in all of their advertising and it's prominently displayed on their boxes to try and prevent that word from becoming a generic word for all facial tissues. I'm not going to spend too much time on trademark infringement here, but if you look at, these are the factors that go into determining whether one mark infringes upon another mark. And if you look at these, you'll see that the focus is really on whether or not a customer would be confused. If they are looking at, standing in a grocery store aisle, looking at all of the products side by side, would they be confused as to whether one is associated with another? If they encountered another in the market, in the wild, would they be confused into thinking that that is from a different company? All right, let's now talk about patents. This is one of the most commonly misunderstood area of intellectual property. Patents are designed to protect new and useful technology. They are some of the broadest exclusive rights in the intellectual property world. They don't require you to, they don't require an infringer to know about the patent in order to be found liable in infringement. That's what we call strict liability. If someone else is making, using, offering for sale, or importing something that is described by your patent and claimed by your patent, they will infringe it. And the penalties, the ultimate damages for patent infringement, especially when we're talking about technology, can be exceedingly high and get very high very fast. So that's why patents are very popular in the technology world and also very well misunderstood. In the US, along with most of the world, we operate on the first to file rule, which means the patent office is the first to be given the patent. There are statutory bars to be aware of. So if you think you are developing patented technology or patentable technology, talk to a patent attorney as soon as possible, because there are a bunch of issues that will arise if you disclose your patented invention or offer it for sale before you file an application for a patent. Some things to know about: patent applications are examined by the patent offices. They must be novel, meaning new, not described anywhere in other written literature, and non-obvious, meaning that they're not just a combination of technologies that were known before. They're actually a leap in invention. They also have to be useful. In Web3 context, that's not as big of a deal. It's mostly for pharmaceuticals or therapies. Let's talk quickly about software patents here, because this is probably one of the biggest issues in software patenting today. Over the past 10 years, two cases have really thrown a wrench into software patents: Alice and Williams. Alice, the Supreme Court said that an invention must be more than an abstract idea to be patentable. But if it is just an abstract idea, then the claims may be patentable if they include additional elements that transform the abstract idea into patent eligible subject matter. You probably don't know what that means. Most patent attorneys don't know what that means. The courts are still figuring out what that means. I'll tell you what we know in a second, but it's still really amorphous. Williams is a similar case that found that a popular method of writing patents, which is using means plus function claims, where you basically describe a patent language using the function and not the structure. It found the Federal Circuit, which is kind of the high court of patents in the US, found that using those terms would render a patent invalid unless you disclosed enough structure behind the term in order to carry it out. So what does that mean? Okay, so if we look at these two kind of simplified graphics, on the left-hand side, this box, let's take it as kind of a recommendation engine. If you just take a recommendation engine for recommending, let's say, podcasts, that engine by itself, not patentable. That's an abstract idea, just saying an engine for recommending podcasts is not in itself patentable. If you go down and you add to it, let's say you add that input, an engine for taking a user's past history of podcasts and running it through a recommendation engine and outputting podcast recommendations. Well, under Alice, that is now a patent eligible invention because it is tied to converting one thing into another. Bit of an amorphous concept, I understand. But if you look at the bottom here, what Williams says is, okay, that's great. That can be a patentable invention, but you have to disclose sufficient structure to let us know what that recommendation engine is. How does it work? You can't just claim the function of it and what it starts with and what it ends with. You have to give us information as to how it does that. So that's how you get currently patent eligible claims, is by tying it to an overall application, input, function, output, and describing the structure to carry it out. Real quick, can patents be granted with so much open source in Web3? Sure. Patents are granted on that kind of stuff all of the time. Most valuable patents are on improvements. Wherever there is documentation, though, that is going to be used. It's called prior art. It will be used to prevent a patent unless it is new and non-obvious. Real quick on DAOs. So DAOs are really interesting in the IP world. It's one of the most, I think, promising applications for DAOs. They can be dedicated entities to own and license IP. This could be IP in the form of copyrights, patent applications or patents, as well as data or data sets. It's kind of like micro investing in research. A couple of big ones down here, but I think this is one area to watch, as it is certainly an interesting application of developing intellectual property. And I think my last slide here, general ideas between Web3 and Web2. There's a lot more passing on, a lot more secondary users that are contemplated in Web3. And so you've got to think about how you pass those terms, license terms, onto those secondary users. And last point here is authorship by algorithm. Again, super interesting, super new area. Copyright Office has said that an algorithm cannot be an author, but like I mentioned before, an algorithm can be copyrighted and it can produce copyright material that is considered to be authored by the author of the algorithm. So there's a bunch of issues that I don't unfortunately have time into going into, for example, seeding AI with, or training AI with others' copyrighted materials. Don't have a lot of time to go into it, but don't do it, especially not without talking to an IP attorney. It's fraught with issues. With that, I'm going to kind of end it here. I see that we've got potentially a few questions that we can try and answer up here.
Yeah, Paul, the first question that I can ask you yours, this is definitely for you. Can an image of private property be made into an NFT and sold? So if someone has an aircraft, let's say, can they take a picture of it, turn it into an NFT? Do they have plenary rights in that picture and the subsequent NFT that they can mint from that?
Yeah, it's going to be highly factually dependent, but under the basically what you told me there. So there's no copyright really in the airplane. Take a picture. If you've got a copyright in that picture, whoever took the picture has that copyright. So if you take someone else's picture of an airplane and make an NFT out of it, you've got to have that permission. Okay, but yes, you could then take a picture of it, but the NFT is not going to be the airplane. The NFT is the copyright or whatever ownership stake you want to take in it. there are NFTs of automobiles, of artwork, right? But those NFTs are really just ownership rights, maybe a section of the copyright or an ownership of the copyright rights to use a particular piece of property, perhaps, but the rights are not going to actually transfer in the property.
Great. I'll tackle the next one. That it was for me. Someone asked, "What is Wyoming the optimal state of incorporation for Web3 projects, or are there other states?" So, from a U.S. perspective, we have to look at a couple of things. One is how friendly. I guess three different things. One is how friendly is the underlying legislation to the DAO model. If we're talking about DAOs, if we're not talking about DAOs, I'm pretty okay sticking with traditional LLCs or corporations, depending on what your tax situation is and whether you have investors or international folks. So there's some kind of general thoughts there. If we're talking about DAOs, there are 5 states maybe in the U.S. now that have specific DAO legislation. Delaware is not one of them, but Delaware continues to be the darling state for companies that want to raise capital and want to potentially go public later. So there are signals. I always describe it this way: there are signals that you as founders can send to your potential business partners, including potential funders, to let them know. Wyoming is trying to position itself as the Delaware for Web3. Delaware will always be Delaware and always be a safe jurisdiction for for businesses, because it is well known. The legislation comes out quickly, and the judiciary is very good and very quick. So there's some very positive things there if you're on the owner side or the developer founding team. But there are other states. Utah just passed a DAO law. New Hampshire, I believe. Tennessee, maybe there are some others. And this really matters depending on what your makeup is and what the project is going to be. Because I have some clients that are mostly international, and they don't want or need a U.S. nexus necessarily. Some of their they're a consulting company, so some of their clients might, and I might set up entities for them in the U.S. But for themselves, we're looking offshore at some of the friendly jurisdictions and I consider friendly those that have not shied away from dealing with the Web3 concept. So those that have a virtual asset service provider regimen in place, regulations in place, and also that have a robust securities mechanism. So I'm not going to look at, say, the Channel Islands necessarily, unless I have a founding team that just literally wants to hide and try to stay away from any type of regulation in any way. For those that, and I would say most of the companies I've been talking to lately, or most of the founding teams, are very interested in compliance in whatever way they can, and they're waiting for the U.S. to get to get together and figure out how the U.S. is going to deal with things like with security tokens and other things that come up in the Web3 context, exchanges and banking. So there are all kinds of things we're waiting on in the U.S. And so that uncertainty is pushing a lot of projects offshore. I'd say Cayman is specifically good. I've looked at their regulations very closely, and the Bahamas is supposed to come out with one as well. And so I would say those two tend to be my primary go-to jurisdictions, because they have embraced Web3 from all legislative angles, and they can provide some certainty. Now, we still can't run away from US related issues if the founding team has US ties or the investor group has US ties, but it certainly factors into the question. So I think that may be it, Paul. I don't know if you have any parting thoughts or you have another question to answer.
I don't really. I think that this, my parting thoughts.
Paul, sorry, one just came in and it's for you.
Okay.
Is the World Intellectual Property Office working in international regulation in Web3 IP? Do you know of anything happening on the international level?
There are a number of organizations that are working on it. Oftentimes, their work comes in the form of recommendations. I'm not aware of anything, I guess, specific that I find super interesting from WIPO, but I'd be shocked if they didn't have a working group that was going to come out with some recommendations. But I'm not aware of anything in particular.
Okay, great. So parting thoughts then, Paul. You want to go and then I'll go.
Parting thoughts just on this is incredibly rapidly developing area, but in the IP realm, there's not a lot of case law. There's not a lot of black and white. So we're operating a lot in gray zone, working on just kind of best principles from applying other best practices from other industries into this. So just be aware of that and watch as it continues to develop. Make sure that your business practices continue to evolve as the IP laws evolve.
Great, thanks. And for me, I think don't check your brain at the door. I think there are a lot of founders that think that because we're dealing with new terms and new concepts on my side, on the corporation, on the entity formation side, and raising capital, M&A, that just because we're using new terminology, that we can do whatever we want, and that's true to an extent, right? We can go and break things, build and break, and build and break, but at the same time, it is good to understand where those lines are, because there are some very definite lines, even though we're still waiting for the SEC, CFTC to give us some guidance, at least on the US side. Paul, looks like there was one more question that came in. I don't know if you have time to answer it.
One more, and I'm racking my brain. The question is if there's any cases concerning copyright or trademark on Web3 that I recommend to follow. I'm trying to think of if there are any active cases. Not that I know of, but I tell you, I am actively really interested in cases, and I keep an eye out for cases that are going to give us some guidance on training AI and what fair use looks like in training AI using others' copyrights. Because there's a lot of instances right now of image generators that use artificial intelligence to go out, they scrape the web, grab a bunch of images, train their AI, and now you can kind of say, create me an image like this, and it uses that training to create a new, ostensibly copyright protectable image. So I'm watching cases that will delineate that. Copyright and trademark are really factually dependent, and so in order for us to have certainty on that, we're going to have to just have volumes of cases. We're going to need a lot of different cases that set out the boundaries. So there's not one case in particular that I am watching on copyright and trademark, but I think that the body of case law as it develops is going to be really important to keep an eye on.
Great. Thanks, Paul. Thanks, everyone, for sticking around with us to the bitter end. We look forward to seeing you next time. And you can contact us on LinkedIn. I do quite a bit on LinkedIn. Paul, I don't know what's the easiest way to get in touch with you. Is that good for you?
Yep, I'm available on LinkedIn. You can always find me there.
Excellent. All right. Thanks, everyone. We'll see you next time.